Florida probate litigation and prior wills. Can I inherit under a prior will, and how do I inherit if somebody dies without a will? Hello, my name is John P.L.C. I'm a probate litigation attorney in West Palm Beach, Florida, with the P.L.C. law firm. We handle trials, disputes, and appeals involving wills, trusts, estates, guardianship, and probate and business litigation, as well as related areas of homestead, real estate, life insurance, and investment accounts. We do not draft wills and trusts, although we do litigate them. Let's talk today about prior wills. Let's say you're involved in an estate or an inheritance lawsuit in Florida, and somebody is attacking the will. Maybe they've filed a petition to revoke probate, or maybe they're contesting the will, or maybe they're doing that to a trust. You can ask any Florida trust attorney who writes wills and trusts, and they'll tell you that many times there's amendments to trusts, restatements of trusts. Revocable trusts and living trusts in Florida are very, very common. And sometimes family members or beneficiaries who've been cut out or had their inheritance reduced file an action to contest that trust or to attack the validity of that trust, much like you have a will contest where somebody attacks the validity of the will. So if you're involved in a trust contest or an inheritance fight and someone is attacking the will, you want to ask your probate litigation attorney in Florida if they know about the doctrine of dependent relative revocation. You also want to know what happens if that will is declared invalid, or that trust amendment is declared to be invalid or void by a Florida probate court judge. So what does happen if a will or a trust is knocked out and it's overturned or ruled invalid? Maybe somebody executed it when they had dementia or Alzheimer's, and they didn't have the requisite mental capacity to know what they were signing. Or maybe their signing of the will of the trust was the product of undue influence, and a judge declares the will of the trust invalid. What happens? Well, you may have one of two very common scenarios. That person may die without a will or a trust. And then the question becomes, okay, well, do the laws of intestacy apply in Florida? Well, generally they do. If somebody dies without a will or any will substitutes that could pass property outside of probate, we have an intestacy law that tells us who inherits your property if you die without a will. Now, those people that inherit are typically your heirs. Sometimes we think of them as descendants and your spouse. But the second common concept that you need to think about is, what if there are prior wills or trust? Let's say the person attacking the will or filing the trust contest in Florida is successful, and the trust amendment is declared invalid, or the will is declared invalid. What if there are prior wills or prior trusts? Do those come back into effect, and are those valid? You need to know about the doctrine of dependent relative revocation. Ask your Florida trust lawyer or your Florida estate lawyer about the doctrine of dependent relative revocation. And specifically, from a probate litigation standpoint, you need to know whether that has been pled properly or not. You may plead it as an affirmative defense. You may plead it in your complaint if you're attacking the trust, if you're attacking the will and you're taking or trying to take or inherit under a prior will or trust. So I want to leave you with one case that will tell you more about this odd, bizarre concept of Florida's doctrine of dependent relative revocation. Think of it as a legal doctrine that revives prior wills and trusts and gives them effect. The estate of Murphy, a January 20th, 2016 Florida appeals court case from, let's see, it's from Florida's 2nd District Court of Appeal. The citation is 184 Southern 3rd 1221, January 20th, 2016. And the estate of Murphy is an excellent case that looks at prior wills and explains and talks a little bit about this doctrine in Florida, when you're in the probate litigation context, of reviving prior wills so that the people inherit under the prior will. And so there's a presumption in Florida that if this doctrine is pled properly, that the person who passed away does not want to die intestate, does not want to die without a will. He or she would rather have his or her property pass under a prior will. That presumption is rebuttable, and you should talk to your Florida probate lawyer or your litigation team about whether that doctrine of prior wills is effective or can be effective, and whether it helps you or not in your inheritance lawsuit in Florida. That's a very important part of your trial strategy and your tactical approach to an inheritance trial in Florida. My name is John P.L.L.C, and this concludes my remarks about will and trust litigation in Florida.